Hi guys, before today's video, I just wanted to pop in with a really quick message to say thank you to all of the people who have donated to the Canadian Constitution Foundation this year. We rely 100% on voluntary donations as a charity to do all the work that we do. And today is November 29th, it's Giving Tuesday, and from now until the end of the year, we have some generous donors who have actually offered to match any donations that are made today up until the end of the year. So if you donate now before the end of the year, your impact to our organization will actually be doubled, and we'll be able to continue doing really important work like our appearances at the Public Order Emergency Commission, our work on freedom of expression, freedom of religion issues. So thank you to everyone. Please consider making your end of year donation to the CCF and the work that we do. Hi guys, it's Christine from the Canadian Constitution Foundation. As you can see, I am not in my office today. I am downtown, but I wanted to film this quick video between some meetings that I have. And I also wanted to show you guys my new glasses. A lot of you in the comments are always telling me that my glasses are broken, that my glasses are crooked. So I've got new ones, so no more complaining, please. Let me know if you like them. Today's video is going to be about what comes next at the Public Order Emergency Commission. This is the public inquiry that's been called into examining and assessing the federal government's justification for invoking an emergency under the Emergencies Act in response to the 2022 Freedom Convoy. Now, the factual hearings wrapped up last week, and now this week is the policy phase of the hearings. As you all know, we were a party to the hearings in Ottawa, and we're also a party to the policy phase, and we're going to be making a few recommendations for policy changes that can be made to the Emergencies Act to help improve it. In this video, I'm going to go over 10 practical proposals for reforming the Emergencies Act that we at the Canadian Constitution Foundation believe will help protect against abuses in the future. We hope that the Commission will consider these proposals. We're going to be expanding on them in a written proposal, and that they will be implemented by Parliament following the report of the Rouleau Commission. The first two recommendations we have relate to when the government can declare an emergency. First, we recommend that to declare an emergency, there must be an exhaustion of provincial and territorial authorities. The Emergencies Act is a tool of last resort, and in the inquiry, Alberta and Saskatchewan made it clear that they were told, not consulted, by the federal government about the act being triggered. Clearly, the requirement in the Emergencies Act that the provinces be consulted needs to be strengthened. The federal government should be required to formally request provincial and territorial authorities to use existing legal tools, including provincial and territorial emergency legislation, before triggering the act. Second, we recommend the creation of a Parliamentary Review Committee to provide real-time oversight. The Emergencies Act should be amended in order to establish a Parliamentary Review Committee that provides oversight on the declaration of an emergency when that emergency is underway. The committee should be chaired by a member of the official opposition who will not have the same partisan pressures to accede to the governmental position as a member of the governing party would be. This is an established practice, actually, in Westminster democracies, the model being the Public Accounts Committee in the House of Commons in the United Kingdom. This committee would have security clearance to receive confidential briefings from and question agencies like CSIS and the RCMP, and this could happen on a daily basis. Our third recommendation relates to the justification for an emergency. We recommend that the government must explain why existing legal tools fell short. The Emergencies Act requires that the federal government table an explanation for the reasons in Parliament, and the explanation that was tabled in this case provides a one-sentence explanation for why existing tools allegedly fell short. We believe that the Act should be amended to require the Attorney General to release a legal opinion that provides a detailed analysis of existing legal tools and makes the case for why they fell short, more than just this conclusory sentence that we were provided in this case. It's become manifestly clear over the course of the hearings that the evidence of police witnesses at every level was that existing ordinary criminal laws, not to speak of provincial emergency laws, would have been sufficient to end the protests in Ottawa. The witnesses only said that the Emergency Act was, to quote them, extremely helpful, but not absolutely necessary. We believe that the Emergencies Act's requirement that it be a tool of last resort needs to be given some teeth. Our fourth and fifth recommendations relate to confirming an emergency. We recommend that the law be reformed to create a supermajority requirement to confirm a declaration of emergency. At present, a declaration of emergency expires if it's not confirmed by a simple majority of 50% plus one. That's in the House of Commons and in the Senate. Because of the extraordinary power vested in the federal cabinet under the Emergencies Act, we believe that a majority government shouldn't have the unilateral power to proclaim an emergency. We believe a 60% threshold should be required, which would necessitate the agreement of opposition parties. We also recommend reforms to require provincial confirmation of a declaration of emergency. The Emergencies Act authorizes the federal cabinet to enact regulations in core areas of provincial jurisdiction. Yet there is no formal provincial role in the confirmation of a declaration of emergency. Provincial confirmation should be required for the two kinds of emergencies that are predominantly domestic in character. That's public welfare and public order emergencies. The requisite consent should consist of at least 7 provinces, which would represent at least 50% of the population, which is the same as the general amending formula for constitutional amendments. Our 6th and 7th recommendations relate to judicial review of a declaration of emergency. We recommend creating a requirement for the Supreme Court of Canada's review. A declaration of emergency can be challenged in courts, but the process is slow, and it may not conclude until well after the emergency is over. The legality of the declaration of emergency should be sent immediately to the Supreme Court of Canada instead of beginning at the federal court. The Supreme Court could hold a hearing on an expedited schedule. Moreover, special advocates with full security clearance could be appointed who would have full and immediate access to any evidence which the federal government seeks to keep in secret on the grounds of national security and cabinet confidentiality. We also recommend expedited review of national security and cabinet privilege. Judicial challenges to the public order emergency have been slowed down because of the federal government's assertion of national security and cabinet privilege over key pieces of evidence. The Supreme Court should have the power to review on an expedited basis the government's claims to keep evidence secret in order to ensure that as much evidence is filed in open court as quickly as possible. Our last 3 recommendations relate to the inquiry that must be called following the declaration of an emergency. We recommend that the inquiry must occur under the Inquiries Act, a piece of federal legislation, so that a proper investigation can take place. The Emergencies Act only calls for the creation of an inquiry into circumstances that led to the declaration of the emergency. It does not spell out the powers of that inquiry. Fortunately, in this case, the federal cabinet appointed Commissioner Rouleau pursuant to the Inquiries Act, which gave him investigative powers, including the power to summon witnesses. But the Act should be amended to provide that the inquiry must occur under this legislation. We also recommend that the inquiry into the declaration of an emergency should be given 18 months to do its work. The current law requires a 1-year timeline, so the report is due within 1 year of the termination of the emergency. While some time pressure is a good thing, sometimes these inquiries can take a tremendous amount of time. The Rouleau Commission in this case has been forced to review an ocean of evidence consisting of thousands of documents in an unreasonably tight timeline. The period for delivering the final commission report, we believe, should be extended to 18 months from the end of the emergency, and the legislation should be amended to say so. Finally, we recommend that the head of the inquiry, the commissioner, should be appointed by an impartial party. Currently, the federal cabinet has the sole discretion to appoint the head of the inquiry, which in our view violates the principle of natural justice that no one should be able to choose their own judge. And it also has the problem that this appointment process could create the perception of bias. Now, Commissioner Rouleau has discharged his role with rigor and fairness. This is not meant as any type of criticism of Minister Rouleau, but we believe that the act should be amended to place the power of appointing the head of the inquiry into the hands of a parliamentary review committee chaired by a member of the official opposition. Let me know what you guys think of these suggestions and how we think the act should be amended. I would love to hear what suggestions you have before we make these submissions final in the inquiry itself. If you want to see a copy of our final submissions when we do file them, you can sign up to receive our email updates at the ccf.ca/freedom updates, and we'll mail out a copy of them when they are finalized. Some of these suggestions were also laid out in an op-ed that we published in the National Post a few weeks ago, so I'll link to that in the description below so you can read it. And of course, as always, if you enjoyed this video, I would love it if you would like and subscribe. It really helps my channel out a lot. Okay, that's all for this video. Thanks for watching, and let's keep fighting for freedom in Canada.